Hello, this is Sudhir Kumar Dwivedi, Assistant Professor of Law from Gemtech School of Law, Greater Noida. The topic for today's lecture is bail application under the subject drafting, pleading, and conveyancing. Our focus will be on the structure and requirement of the bail. Let's first see what is the bail. As we know, that the term bail is not defined under the CRPC. Bail is considered as a kind of security which is given by the accused to the court that he will attend the proceeding against the accusation made upon him and includes personal bond and bail bond. As we know in the criminal justice system that a person may be arrested under warrant or even without warrant, and one important purpose of arrest is to secure the presence of the accused person at the time of his inquiry or trial and to ensure that he is available to receive the sentence on conviction. This is the one important purpose of the criminal judicial system. If this purpose can be achieved without forcing the detention of the accused during inquiry and trial, it would be ideal. You can see the blending of two apparently conflicting claims, namely the freedom of the individual and the interest of the justice. This provision relating to bail aim at such blending. They have been enacted with a view to restoring the liberty of the arrested person without jeopardizing the objective of arrest. We know that in CRPC there is a provision regarding the bail, and bail when and when not be granted. Let's see some provisions which has been provided in CRPC. As per the Code of Criminal Procedure 1973, there is two category of the offence. Bailable offence, the offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and the term non-bailable offence states that meaning any other offence other than bailable offence. So if you will analyze this provision, that is bailable and non-bailable, then it, as per this, it just provide a category which offence is bailable and which offence is not bailable. If it is shown is bailable in the first schedule or any other law, then it will be bailable, otherwise the offence will not be bailable. So the basic rule of grant or denial of the bail may be simply summarized as there are only two kinds of offence, that is bailable and non-bailable offence. In case of bailable offence, section 436 of the CRPC, as per this section, it is the right of the accused to demand and be granted the bail, and the certain basic criteria while exercising the judicial discretion for grant or denial of bail in case of non-bailable offence has been laid down in section 437 of in the cases related to non-bailable offence. Some of these criteria may be like what is the nature of the offence, whether it is serious, grievous, or it is a simple nature, past criminal record, whether the accused is the first time offender or he is the habitual offender, the probability of guilty, how much probability is there that it is the accused who is only has committed the crime, and also there may be various factors which may be taken into consideration before granting the bail. These are some examples only. There may be some ground like what is the chance of that the accused will flee off from the jurisdiction of the court, what is the liability of the accused in social life, what is the age, various factor may be taken, what is the family liability, various factor may be taken into consideration at the time of the granting the bail in non-bailable offence. How? Because since it is a discretionary power, because you can't limit, it may vary from case to case. That's why this discretion has been given to the court that in non-bailable offence, after taking into consideration the facts and circumstances of the case, bail may be granted or not be granted. And again, under section 438 of the CRPC, which deals with the anticipatory bail in cases where there is an anticipation of the arrest. There is certain provisions where the police officer may also give the bail. The police officer power to release a person on the bail who has been accused of an offence and in custody is may be categorized in two heads. One, when he has been arrested without warrant, and when he has been arrested with warrant. Now let's see what will be the structure of the application which is filed for getting the bail. It will be like that. If the application has been filed, again keep in mind that you must have a knowledge about the jurisdiction of the court. Then only you can file an bail application. In the court of, suppose here I have taken an example, in the court of Metropolitan Magistrate District of any district like Sahadra, Delhi, and then you will number of bail application will be provided by the registry so and so of 2017. After that, there will be a detail of the case. That state, generally you be know that in criminal matters the state is a party. State versus so and so, then the complete detail of the applicant, his name, son of, residence of, and age, and all things must be provided. Then the FIR number in right corner, the FIR number under which section the of he has been arrested for what police officer has filed a charge sheet under which section, or if not filed then for which offence he has been arrested. If it is mentioned, then it should be mentioned that he has been arrested under section so and so. Then by which police station, the name of the police station must be given in the right corner. Then it will be like that, application for grant of bail under section 437 of the CRPC. The accused above named most respectfully swear that the accused above named was arrested by the police on 1st January 2010 and is in judicial custody since then. From when he was arrested, the date should be very specific. It is alleged that on so and so date, the accused was suspiciously moving on Baba Khadak Singh Marg, New Delhi, when the police apprehended him, conducted the search, and recovered 3 grams of smack from his pocket. What happened on that particular day when he was arrested? The first statement should be regarding that. Then, that the accused has been falsely implicated in the instant case and he has nothing to do with the alleged offence. Then the third para will be that nothing was recovered from the possession of the accused or at his instance, and the so-called case property has been planted upon the accused. It was not recovered from the accused, rather than it was put in his pocket by the police while they were searching, so that they can falsely implicate, if you can mention like that. Then that the accused is a law-abiding citizen and belongs to a very respected family. He has never indulged in any illegal activities and commands respect and admiration his locality. As I already discussed, that here you may give his personality or family background, that you are not a habitual offender, where you are having a status in the society, so that the general presumption about the accused which is in the society may be taken into consideration by the court. Then the next para will be like that in November 2015 the accused found some person selling smack near Hanuman Mandir, Connaught Place, New Delhi. The accused immediately reported the matter to police, as the result of which the police also arrested some of the person. Since that time, those persons who were arrested at that instance of the accused were threatening the accused to falsely implicate him in criminal case in collusion with the police. The accused made a complaint in this regard to Deputy Commissioner of the Police, and true copy of which is annexed here to as annexure A. So, if there is some situation like that, you have the person who has been arrested in this seeking bail, he has made some complaint, and on the basis of some people have arrested and they have threatened that they will falsely implicate with by colluding with the police, then you should state those facts very specifically and very clearly. After that, that the after the said complaint, the accused was called by the Vigilant Department Delhi Police, who required into his complaint the true copy of the said notice issued by the vigilance cell is enclosed herewith and annexed. And if there was some notice has been issued and some inquiry was done, then you must file the that notice and a copy of that notice to support your statement. Then that is then it is imaginable that the accused who made a complaint against the seller of smack would himself indulge in such activities. So here you are giving some trying to made some presumption in the mind of the court that the person who was once complaining regarding the smack selling at that public place, then he himself may involve in that case. How it is possible? It is unimaginable. Then the next para will be like that the accused is a permanent resident of Delhi and there are no chance of absconding in a case he is released on bail. So we discussed that there must be a statement regarding that if he will be released on bail, he will not leave the jurisdiction of the court. After that, the next para will be that there is no chance of the accused absconding or tampering with the prosecution evidence in the event of release on bail. So one next statement will be that if the person will be released, the applicant will be released on the bail, he will not tamper the evidence, he will not affect the witnesses and all things. Next para will be that the accused undertakes to join the investigation and when directed to do so. The next statement will be that he will always made available for the purpose of the investigation. Then that will next statement will be that the accused is not a previous convict and has not been involved in any case of this nature except the present case that we discussed in the initial stage of the lecture, that you must show that you are the first time offender, you are not a habitual offender. Statement regarding that must be given in the bail application. Then there will be next para will be that the present case is a result of clear manipulation by the police. Obviously you will give some doubt over the police action. Then the accused from all counts is innocent person. Obviously you must mention that you are the innocent one in the present case. Then there will be prayer. It is therefore respectfully prayed that the accused may kindly be released on bail during the pendency of the case. Then the sign of the applicant through the advocate, place, date, and again it is to be noted that affidavit of the applicant and wakalatnama duly attested by the jail authorities must be presented before the court with the application of the bail. So here it is to be kept in mind that there are some general ground which must be taken in all type of the bail application, which will increase the chance of getting the bail, though it is the discretion of the court and that always depends on the fact and circumstances of the case. That's all about the some basic points of the bail and its structure. Thank you.